Okay, so welcome to, this is now the second presentation I've made to begin the process of explaining the proposed rules for dispute resolution that the advisory committee has been working on. And I want to do a little bit of background to give some context to how we got to where we are today. Very briefly, mediation started in Kansas in '85, or at least it was codified in the statutes then, in domestic disputes. Then a couple of years later, we got the Supreme Court rules on dispute resolution. And then a number of years later, we have the Dispute Resolution Act. Those are sort of the core of our dispute resolution statutory and legal structure right now. And we're talking about revising what was first implemented in '87. So we're about 30 years down the road. And that's one of the reasons why we felt it was time to take a look at the state of dispute resolution in Kansas. There has been a lot of innovation, a lot of trying some new things, and to try to bring some order and rational structure to it was the purpose. You see, the case management came in '96, and then in 2012 and 2013, the Supreme Court issued 2 administrative orders relating to case management. And it was in February of 2015 that the Advisory Council formed a subcommittee to draft modifications to 901 through 904. And we actually had an initial packet in the summer of 2017 that went to the court. About a year later, there still had been no action, but we were getting some feedback in terms of maybe having it looked at by some of the specialists who have worked on rules. Maybe we tried a different format where we pulled some of the detail out, and we were going to have a slimmed down packet because we weren't sure whether that was intimidating the court, and have detail in what we called standards. And we had that ready to go to the court, and they then, through some of the experts, they had Nancy Strauss, who is the executive director of the big Judicial Council, and she has been through several rule reviews, and she said approval is equivalent to licensing, and therefore we need to have all the detail. If people can lose their ability to practice or take cases from the court, it needs to be very easy for them to find out what's expected. So everything got put back together, and it went fairly rapidly from that to a final approval by the full advisory council in November of 2018, and then the court decided they were ready for it to go for comment. So we've gone from, we had about 20 plus drafts that the subcommittee worked with over these 4 years. And we've gone from 4 rules to 18 rules. Now, we have incorporated virtually everything that was in those 4 rules. It's in different places. We've pulled things apart and tried to make it easy to follow, and we got a lot of assistance from that on Nancy Strauss. She really made it very readable, at least we think it is, in terms of how it's broken up into its various subparts. So that's kind of the history. Before we go rule by rule, I wanted to hit what I think are the major modifications that we want to be aware of. First of all, it restructures, clarifies, and conforms all of the dispute resolution provisions and requirements that exist and it adds some, and like parent coordination, which is not in statute, it's not in rule, it's nowhere, but it's being done. Same thing with domestic conciliation. So it both takes what's there and restructures it and formats it and conforms it, and it also adds. So what it adds or substantially expands are 6 categories for formal state approval. Right now, there is only one that gets formal approval from Dawn's office. Case management, you have to qualify, but there's nobody that gives you a certificate. So now we're going to be expanding that to 6 categories that will include domestic conciliator, parent coordinator, domestic case manager will now come through this procedure. Mentor mediator will be formally approved in a way that it hasn't. I assume she'll issue some kind of document or certificate. Program providers, they will go through a more formal process and have to provide formal annual reports. And the mediation practicum, so that's what we used to think of as co-mediations, will now be part of the mediation practicum, which we'll talk about in more detail about all of these. It deletes the category of approved trainers, which doesn't mean that there aren't expectations of trainers, but it's not going to be a formal approval process. As we talked more and more about it, there was just a sense that it's too hard to really manage and be able to validate that we have approved trainers, because the requirements were so minimum anyway, and Dawn did not want to be in the business having to go to actual trainings and watch and see, was this a good job or not, the way a dean might go into a classroom or a principal. So you'll see that we've tried to address that problem in a different way. It clarifies and streamlines training and CDRE education requirements, and in some cases expands what you can use to get CDRE credit. And it's called CDRE because it's now is going to cover not only mediation, so it used to be CME, but it will be covering, CDRE will apply to any of the approved categories. Okay, so it stands for Continuing Dispute Resolution Education. It formalizes the process for obtaining co-mediation experience through the practicum. And yeah, why don't you join? We got a couple of chairs right here. That way I can look at you. Okay.
Oh, on that side?
Yeah, there's 2 spots there. And then if you can just also sign in here. I just started, basically giving a little history. So that this is really sort of a 30-year review from '85 when mediation first started. We're about 30 years down the road, and a lot has happened. So that was the impetus. And then we were going through the major modifications. And before we actually tackle the individual rules, but we will cover all of these as we go through the rules as well. Okay, so we were down here. It formalizes the co-mediation experience into a co-mediation practicum. It expands the ethics rule to cover all approved providers in addition to mediators. So all categories of dispute resolution specialists are now required to comply with the ethics requirements. Mentor mediators, as well as approved programs, are specifically now bound by the ethics rule, which has been expanded. It covers everything that was in 904, but it 903 and 904, but it also includes more. Okay? Any questions on that before we move on. Okay. It also adds a process for the advisory council to receive and investigate complaints. And in the very early dispute resolution statute, there was supposed to be a complaint process developed. And while there was somewhat of an internal process, it was not anything that anybody could go online and say, how do I file a complaint about somebody? Or a mediator couldn't say, what do I do to defend myself? So we now have a process in these rules that sets out how all of that happens, and we'll go over those as well. Okay, you all have a copy of this chart before you, and it might be easier to read it. But what I wanted to do before we look at the rules themselves is to give you a sense of what we tried to build, which is a continuum of interventions dealing with domestic disputes, which is where most of our dispute resolution work happens. From least intrusive into the family to most intrusive into the family. And we did this in terms of how they're defined, what the training requirements are, any additional qualifications, and the actual process. So that's what this chart is designed to kind of show you, the skeleton of that continuum. So in domestic mediation, the definition there that's in the proposed rules is assisting the parties in defining issues, facilitating communication, and helping parties reach resolution. There is no decision-making authority. By comparison, domestic conciliation assists the parties in reconciliation efforts by doing the following: improving communication, reconciling differences, helping the parties develop solutions to a dispute, complaint, or conflict. And again, there's no decision-making authority. So people could say, well, that seems like kind of the same thing, but we'll see in terms of training and the process where you have some distinction. Parent coordination is assisting in implementing court orders and daily parenting matters. So they are not coming in and helping negotiate the initial parenting plan, but they're coming in afterwards when there's difficulty for the parents in actually implementing the plan. They can work with minor adjustments, and they are focused on educating the parties, assessing their parenting skills and the child's needs, coordinating professional services for the family, and assisting them in reducing harmful family conflicts. So day-to-day disputes, definitely they help the parties work those through. So there is limited decision-making authority. Okay, that's the rule says specifically they cannot address issues of custody. Mm-hmm.
In the past, did they also have the comply with the psychology and all of that? Was that also part of?
That's not part of parent coordination. No.
It wasn't in the past.
No, it's parent coordination has never been statutorily addressed in Kansas.
Okay.
And so what we've done is follow the AFCC guidelines in terms of I think they recommend that. They see the pluses and minuses of both legal and behavioral science people, and that if you're one, you need training in the other, and that sort of a thing. But there's no exclusion or sort of these are who can do it and these are who can't. Okay?
I thought it did, so that's great.
Yeah. Case management then is the most intrusive because they can make recommendations on custody. And there, again, this is the statutory definition, is to assist the parties by providing a procedure other than mediation. So we don't talk about case managers mediating, we talk about them helping the parties negotiate, which those of us who mediate realize that's what we do too, but this is the language of the statute, which there was no authority to change that. So they use, they facilitate negotiation to help establish parenting plans, as well as to work with parents who already have a plan, but it needs additions or modifications. And if they can't come up to an agreement, then the case manager makes recommendations to the court. Recommendations is here in the definition because that's a primary job of case managers. Parent coordinators may make reports or recommendations, but that's not a primary job. Their primary job is really coaching the family. And so this is the continuum that we established. Training, you'll also see that training is different. They all have the initial domestic mediation training requirements. That's those top 2 lines there in the yellow. Then domestic conciliation has an additional 6 hours in conciliation training, and an additional qualification of having mediated 10 domestic cases. Okay? Parent coordination has an additional 16 hours, that's 2 days, and I don't know, it's been 5-6 years ago, Art pulled together a subcommittee to try to come up with a protocol template for parent coordination training, and that's been offered now Johnson County for the last few years, so it's available, those 16 hours. And in addition, parent coordinators have to have mediated a minimum of 10 domestic cases. And for case management, they have also will need to take a 16-hour basic training course on case management. And their extra requirements come from the statute, and the statute simply says they have to be qualified to do mediation and experience. So the qualification comes from the domestic mediation training. The experience is 3 domestic cases. These are people who, if they're attorneys, they have to be also have 5 years of experience practicing domestic law, or they have to be in the behavioral sciences at the master's level or above. CSOs, unless they have that master's, would not qualify. All right, and then in terms of the process, the top line there is what only domestic mediation is confidential. The other 3 are not confidential because there is the possibility in all 3 of those of providing some kind of reporting or recommendation to the court. And in order to do that, you might have to talk about what you heard when you visited with the parties. In domestic mediation, the appointment ends when the parties either reach agreement or impasse. In domestic conciliation, the appointment ends with a report to the court or as otherwise set out by court order. And my understanding is that domestic conciliators' reports are very different from, say, a case manager's report in that they really are summarizing for the judge as preparation for a hearing or a trial. They are not making recommendations. They may make suggestions of resources or things to take particular note of, but it's a very different thing, even though it has the same words. That was hard to deal with in terms of what you put into a rule, but we know that is the practice, that they are not actually making recommendations where they set out this is what should happen. In parent coordination, they're appointed under these proposed rules for up to 24 months. That appointment can be renewed. I think the standard for AFCC is 18 to 24 months. So that's probably the range that we're going to be looking at here in Kansas. And for case managers, their appointment is for up to 3 years. That's a big change because it has been indefinite or up to the child reaching the age of 18. And this way, there's a point at which everybody knows we're going to renew it, we're going to look at it. The same case manager could be reappointed, or you could get a new case manager, or you could decide, well, the parties don't need case management at this point. So there's a time for review there. And then the bottom line is sort of what's the result. And in domestic mediation, the mediator can write up the parties' agreement, and if there is none, they have to terminate the process and return it to court, probably with some letter saying, we met, we didn't reach agreement, and we're returning it to the court. Domestic conciliation, they write reports to the court, as we've talked about. Parent coordination, they also have the ability to write reports or recommendations. My understanding is a lot of the practice is that those are oral reports that are made at status conferences, but that's kind of up to local practice. And case management, again, they write reports or recommendations to the court. Any questions about this sort of summary? Because then, we won't need to go into so much detail in the actual rules, but this is all captured in each of the rules on each of these specialties. Okay, and I think on your copy you have the name of the rule up at the top there, so that'll be a little easier reference. Okay. Then I think we're going to switch out and go to our statutory rule. So if you, I don't know if...
I've got an idea. What if mind if I borrow that a moment and we just make this just a little bit bigger? And then you can scroll
Okay.
through it like that as needed. And then
Okay.
I think they'll be able to read it on the screen.
All right. Okay, the prefatory rule just talks about what's going to have to be repealed in terms of B, the formal rule, where the authority for all of this comes from. We actually spent a lot of our initial time figuring out what authority existed for the advisory council and the Supreme Court to adopt rules, what was the scope. And so that's why that is specifically noted there. That's where the authorization, and if you look particularly over here, you'll see a lot of language that says that the dispute resolution coordinator and the advisory council are to make recommendations to the Supreme Court on rules and various, aspects that are needed to administer the Dispute Resolution Act. So that we're pretty confident that there's authority for doing what we're doing. And then application is in each of the rules, but this is in general, tells us that it applies to individuals who are seeking approval for any of those categories that we talked about, and for an organization that is seeking to be recognized as a program to provide dispute resolution. That would be actual cases. So the programs that are doing mediation for the courts or conciliation or what have you, programs that want to put on approved training, that's that initial training, or who want to provide continuing education, they have to comply. Mentor mediators, if you're going to mentor, it's not going to be good enough to just say, I'm experienced, come and sit in and watch my case. You're going to have to be formally approved. And any approved person from here on out is obviously covered, for purposes of renewal and for purposes of following provisions as well as the ethics. And it covers any dispute other than litigation referred by a court to dispute resolution, okay? So that's kind of a catch-all. This authorizes the director to provide and require use of standardized forms. That's kind of the next stage. If this does get approved, then we're going to spend probably the rest of 2019 developing forms, hopefully as many online fillable forms as possible, because there's a lot of reporting, particularly for programs. that's going to have to be done. There's a lot of templates we're going to want to have because there's agreements now, that written agreements that are going to be required for practitioners to have. So that's still to become. I don't have those to share with you, but those will come later.
And if I could,
Yeah.
are they going to have standard mediation agreements?
They will have a template, yes.
Okay.
Well, you know, and I think you will see that there's now a lot of requirements about what needs to be in the written agreement, and so we will have language that will cover what would be acceptable.
Good.
Which means you could have more stuff in there, because everybody's fees is going to be a little bit different, but there'll be some of that others that will be standard, yeah. Okay. And I know that the plan is to put a lot of that on the website as well, and there's going to be, the court is having a whole new website, and we're going to have a page for dispute resolution, and that's where everything will be available. All right, definitions. I'm not going to spend a lot of time on this. I want to say that if you look at the old definition, it had some dispute resolution processes that we do not have in this. We had them in originally, but we were told as a matter of form that we should only include definitions that we actually talk about in the rules. So you won't find arbitration in here, even though arbitration is in the Dispute Resolution Act. Mini trial, neutral evaluation, settlement, or summary jury trial, because they're not actually addressed in these rules. They are a type of dispute resolution. They are covered by the Dispute Resolution Act, but they are not monitored at this point by the Director of Dispute Resolution. If at some point they would become, we'd start, approving arbitrators, then they could be added. Okay.
Is this changing it so that someone has to be an actual approved mediator to mediate a case for the court? It's
Yes.
not just someone that the couple
Yes.
picks out and says they can do it?
Yes. Yes.
I like that.
Yeah, I think we've covered the definitions of like conciliation and case management in that summary chart, so I'm not going to spend more time on the definitions unless you have questions. So 907, mediation. You'll find everything that was in the existing rules in here, plus a few things. So I want to highlight the additions. I have done a pretty careful line-by-line evaluation between the old rules and kind of checked off in the old rules each sentence that actually got in there. So I'm pretty confident I'm going to be pointing out what's different. If you look at 907C right here, the court has to issue an order for mediation on a court case, which apparently isn't always the case. Sometimes it's just an order from the bench saying, in some of the bigger counties or even smaller ones, I suppose, just telling a CSO who's an approved mediator, okay, go down to the basement and start mediating. The mediator must receive a written order. Okay, that's going to be new for some situations, because some of them are from the bench. They might not currently end up with a written order specifying the dispute to be resolved. Okay, and it might be just to help them with a parenting plan or address custody or whatever it is, but it'll be there. And that order has to include a statement that mediation is a confidential process. Okay, that it now needs to be, and that's probably going to be new for every order. I know that it isn't in our court orders even.
What about all the ones that we get that have not gone to court yet?
You mean it's voluntary mediation?
We're getting a lot that come to us before they go to court just to make the process.
Well,
faster.
The court has probably ordered it.
But if the court has ordered it,
They haven't?
No, we've got couples that are saying, I'm going to get divorced. I know I'm gonna
that's
have
going to
go
be different than
mediation,
this.
So we're going to do that first.
That's different, that's voluntary, it's non-court ordered. But as has been the past, people could always do that in the past, and I think most mediators still were approved because it was a way of assuring people to have confidence in them, and we assume that will continue. But this is for court-ordered processes. So here's where it requires a mediator to enter into a written agreement with the parties, and at a minimum have these items that are listed below. So you've got to have an explanation of the fee, and what you do in the case of postponement, cancellation, or non-appearance, if you have a policy on that. If there's going to be an apportionment that's ordered by the court or it's agreed to, that has to be in there. And then a statement that the apportionment is modified only by written agreement of the parties or by court order. Now, when I first read this, my concern was, well, if as in my case, our fees are individual based on where they plug into a sliding fee scale, and then somebody loses their job and all of a sudden, they should be at the lower end and they were at the high end, and they come to you and they say, we haven't started mediation yet, but you assessed me here, but I really am only here. I was concerned that I would have to go get a court order or get the other party to agree to lower that fee, but I think it would apply up here to the fee that's been agreed to, because it's not an apportionment. Apportionment is where, in a case, a judge says, okay, Mom, you're going to pay 80% of the case manager's fees or the mediator's fees, and Dad, you're going to pay 20%. That would have to fall under here, and it would either have to be by agreement. But if we're just using a sliding scale and they are not linked in any way, then I think you can modify when someone has hardship or they lose a job. Okay, then you have to have the method of payment in your agreement, your billing practices, any advance payment. You have to have a statement of confidentiality. This stuff was all in the prior rules that you had to tell them about this, but it's in a written agreement. Where I practice in the 9th Judicial District, we have already had our agreement is about 4 pages long, and it just has all of the stuff in it already. And I'm sure that the template that we produce will have that, so everybody doesn't have to create new language. But these were all obligations of mediators here. The one that is different is E, and this specifically says that while you can't tell the judge anything about the mediation proper, you can report to the court whether a party appeared. All right, and I think people have been doing that, saying I haven't been able to go forward because so-and-so, didn't show up. I contacted them. That should still be okay, and this is making it explicit that you can report that. Okay. This is also new, domestic violence screening. It isn't new that you've been expected to screen. But what is new is right here, continually monitor each dispute. So even though initially you felt you had screened it, you have to pay attention and continue to be aware and monitor it. It doesn't mean you have to keep screening, but you have to be educated enough to know signs and symptoms, pay attention, check things out in caucuses or what have you, and certainly address the issue in how you help develop a parenting plan. And if going in there have been issues, that has to be something that you help with the reality testing. Is this really going to work or exacerbate something? The 2 items that are new, 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 2 The rest of these have been part of either the old ethics here about making sure that power is not imbalanced, and that you have the competency to do the dispute that you're working on, otherwise you need to get out if it's more complex than required. All right, any questions about mediation? All right, next one is domestic conciliation. This, of course, is entirely new. There's no regulation at this time of domestic conciliation. Again, if this just emphasizes the comment you had made. This is court ordered that we're talking about. Somebody could voluntarily ask for conciliation and it wouldn't fall under this rule. Again, this is what the conciliator does. Court has to determine it's appropriate, and they must appoint someone who qualifies under these rules if the court is doing it. And you will see that in all of the rules we have some very similar requirements. Every one of them is going to have a requirement like this. Mediation did. I just didn't point it out because it was already what we knew. But domestic conciliation will have this same thing about the court has to appoint somebody who's qualified, also in parent coordinating and case management. The second section will always be qualification. So there's going to be a pattern and structure that you can follow through each of the rules. So you have to be an approved domestic conciliator under Rule 911. 911 is just the approval process. Or if you're an attorney. So the reason we have to have a second paragraph for attorney for these is because the dispute resolution statute talks about the people who can conduct processes for the court being individuals who are approved, or, and this was added after the initial rule, after lobbying by the bar, or an individual licensed to practice law in the state of Kansas. And so that doesn't just refer to being a mediator, that refers to providing dispute resolution processes other than litigation. So we have this paragraph in each of the dispute resolution rules. So a district court can appoint an individual licensed to practice law. Before appointing an attorney to be a domestic conciliator, the court must consider the attorney's knowledge and experience in domestic relations cases. Okay? So we're encouraging, a lot of the purpose of this rule is to educate judges about what are the processes available, what's the difference between the various processes, and why is it a good idea to have somebody who's been approved and been trained, and if you don't, at a minimum, this is encouraging them to make sure they actually have some experience in domestic law and working with families. And it says explicitly, an attorney who has not received a certificate of approval under 911 is not considered an approved conciliator. So the judge has no illusions that while you can do it under the statute, which we have no control over, it's not the same as an approved conciliator, okay? And it'll be the same, I'm not going to emphasize that in the other ones, but it'll be the same for parent coordinator and case manager as well. Again, here we have the court order, that you have to receive a specific written order. And in this case, the order from the court has to include that it is not a confidential process, and explain what that means, and that it means the parties are waiving confidentiality. Okay? So that has to be in the order, and that's again why we're going to have a template, so that all of the courts will be able to have similar language. And also to advise that the conciliator has a responsibility to report or to the court or other authorities as the court directs. Okay, so it's going to the court not to the parents, which is another difference between parent coordination and case management, all right? Unless the court orders something different. So the order has to also specify whether the conciliator files the report or not. And in some cases, maybe they will just say, I want an oral report, or what have you, but they have to explain what they expect. And they also have to explain what information they want included. And if they just want, you know, something about the developmental needs of the child, then that's what the report would be limited to. If they want something else, then they have to be explicit. The order also has to talk about, can they communicate with each party and under what circumstances? Can they communicate with a non-party? That would include children, that would include children's therapists, or, you know, pediatricians or what have you. That all has to be specified. And if it's to a non-party, if they're going to allow them to do that, then there has to be an order for the parties to execute a release. And again, we would have templates of those releases, because those are used regularly with case management, so they already exist. And again, these things, these contents of the court order are going to be similar in parent coordination rule and in the case management rule. All right? Identical language. And then that order has to address the allocation of fees, including whether, you know, if it's going to be on a sliding fee scale and not allocated, that's fine, but it should be in the order. Any apportionment. And then here, any fee for domestic conciliation should be based on actual time expended related to the dispute. All right? It does not include costs for professional time wholly unrelated to the appointment. This has caused a little anxiety for people who see it for the first time. It comes directly from Court of Appeals cases related to case management, where the case manager was challenged by one of the parents, and they were wanting to get that case manager knocked off the case, and the case manager was asked to come to court to respond and billed the party for the time in court responding to the party's challenge. And the Court of Appeal said, you can't charge the party for your time defending against them trying to get you knocked off the case for being biased or what have you. That's not technically part of your order to provide services. So this is simply saying anything you have to do to comply with the judge's order, which is to interview the parties, to interview non-parties, to write something up, even to come to court to testify or answer questions about your report. That's all perfectly within your scope and would fall under actual time expended. It's just where somebody's basically saying, I move to have this person removed, that you would not include that in your billing. All right. Again, that you have to enter into a written agreement. Again, you have to do the continual monitoring of domestic violence, as well as the initial screen. And then here we have, and this is something doesn't exist in the mediation rule, but it does in the parent coordination and the case management rule. The district court may permit withdrawal of or removing a domestic conciliator if the court finds. And this is where the stuff, if you had to go to court and you wanted to argue against it, you don't charge for this stuff in this section. Loss of neutrality, non-payment by a party, and that's a reason why the specialist might want to get out, because they're not getting paid. Lack of cooperation, threat to a party or the domestic conciliator, or any other reason found by the district court. These are taken identically out of the case management statute. So again, we didn't cook them up. We took what was already there and just applied it to domestic conciliators and parent coordinators. Any question about that? All right, parent coordination, this should go even faster because we've talked about a lot of the sections in here. Again, the definition here, court has to determine that parent coordination is appropriate, and then we have actually articulated here what makes a case appropriate for parent coordination. And again, we looked at AFCC, we looked at other states to try to take the best language. So you have to find A and B and one of the items, at least in C. Okay, so you have to have persistent conflict over child-related issues. They could be in conflict over property, and that wouldn't qualify. It has to be in the best interest of the child, and it has to have one of these, including this catch-all. The district court otherwise determines it's appropriate. So we've got a catch-all, but we want to focus on these right here. The communication and problem solving is ineffective, history of substance abuse, history of domestic violence, mental health or behavioral issues of a parent, child with special needs, or as the court otherwise deems appropriate. And then, again, district court has to appoint someone who's qualified. And the qualifications are approval under 911, and again, you have the attorney exception. And they require here, if you're going to appoint an attorney, should have knowledge and experience in domestic cases. And that if you don't have approval, a certificate under Rule 11, you're not considered an approved parent coordinator. The court order and what it should include. And again, it has to include the dispute to be resolved, the term of the appointment, and that's where it's up to 24 months. And some language that at the end of this, it's going to be reviewed for renewal and possible reappointment, that it's not a confidential process, has to specify whether reports are going to be written and any information that has to be included in the reports. It has to include the right or how they go, who they can talk to, parties, non-parties. And here we actually list who might those non-parties be, which we didn't in domestic conciliation, and that's largely because it's not done there very much. Most of conciliation is done with parties. So here again we see a distinction, but we're talking about the extended family, attorneys, school official, mental health provider, anyone that the coordinator believes has a significant role in contributing to or resolving the dispute, and that the order has to require written release by the parents to facilitate that. It has to indicate, again, that whole issue of the allocation of fees. And then this requires the parenting coordinator also to enter into a written agreement that includes the parenting coordinator's expectations and procedures. So how am I going to meet with you? Individually and then together, or how are we going to communicate? Am I going to take communication every day of the week and 24 hours and 7? Or, some parent coordinators will say, I look at my emails on Monday and Tuesday and Friday. Don't expect anything from me Wednesday and Thursday. Whatever your system is has to be articulated to the parties here. Billing practices, method of payment, use of collections, any other information that is necessary to provide to the family in parent coordination. Same domestic violence screening paragraph and the requirement to continually monitor. This one now has this language for the first time about objections to the report or recommendation. Again, that's because the reports from the domestic conciliators are really for the judge's preparation. They are not a final recommendation for an order that's ready to go, which is what a case manager or a parent coordinator might write, and to which there need to be, as a matter of due process, the right to make an objection, okay? And that's been made clear by the Court of Appeal, that case management works partly because parties' due process right to have it overseen by a judge is taken care of through the objection process. And the same language on withdrawal or removal that we talked about before is identical here. Any question? Any questions on parent coordination? Okay, case management. And this is language that is pulled right out of the statute to every degree possible. In terms of definition, court has to determine it's appropriate, has to involve at least one of the circumstances identified here. Now, we didn't, in our initial draft, we put them in, but we were told that as a matter of style, you don't repeat the statute. Even though it would be easier, and some people have commented that this is unwieldy because now they have to have the statute as well. But apparently this is appropriate style and format, not to repeat the statute. And it means that if the statute is revised, we don't have to worry about going back and revising our rules. So there are parameters, and this directs the judge and everybody to those parameters. And you must appoint a person who meets the qualifications under B. Who does? These are the requirements under the statute, and that is A is, I believe, the attorney with 5 years domestic experience, or maybe the A is the one with the behavioral sciences with masters and above, and B is the attorney. C was for CSOs, but this has been left out specifically from the input of the court. And that's what they had already done in Administrative Order 266. They had said if you're a CSO, you have to have one of those licenses. So the court can hire people with master's level work, and then they can do case management work directly for the court. And has received a certificate of approval under 911. This is new, to require them to be approved through this process. We'll see what happens. So then the court order, again, is, as we've seen in the other language, a court has to issue an order, has to be in writing, the case manager has to receive the order before they can start the process, just like we've seen in mediation and the other two. And the order has to include these same kind of provisions: specify the dispute, specify the term, and this one is up to 36 months, which is 3 years. Specify that there'll be a review at the end of that. Specify that it's not a confidential process, that the parties are waiving confidentiality here, same language. Specifying what the court wants in terms of reports. In the case management orders that have been developed now after a wide number of years, there's a lot of good templates, and those include language on filing objections as well as part of this whole thing. Something about communicating with parties, with non-parties, and again, it's the same language of who might you communicate with, and requiring execution of a release. A section on the apportionment of fees. We've already talked about that, whether it's apportionment or just directing that they pay the fees under whatever sliding scale is required by the court. Or they may simply say under the fee scale of the case manager, but that needs to be in the order. And the case manager has to enter into a written agreement, just like the other dispute resolution specialists, talking about what are their expectations and their procedures as a case manager, the payment, collections, etc. They have to do the same domestic violence screening and continually monitor. Here is new, not in the statute. Sedgwick County, the 9th Judicial District, and a number of other districts, a number of years ago, started using something called limited case management. And limited case management is limited. In practice, it has been limited as to issue instead of, okay, I'm assigning you to this family till the child's 18, whatever their problems are, you deal with it. It is saying, I want you to address the issue of custody, or I want you to address the issue of school, which school is the kid going to go to, and that's the only thing we're doing. And so your term is up when you filed your report on that. So it's limited as to issue and as to time. And that's how this is defined here, and that's how limited case management is defined in the definitions. And this is simply saying that limited case management is subject to all Supreme Court rules and all laws on case management. There's been some dispute on whether limited case management is its entirely own new breed. The courts of appeal have said no, it's a type of case management, and this is just affirming that as well. So then, here's the section on objections, and this has some on objections. There's a lot of local rule on objections as well that would apply. Withdrawal or removal, instead of writing those things down, which we did in parent coordinator and domestic conciliator, it's right there in the statute. And under that form rule, we haven't written it out. We did originally, but it got bounced out. So any questions on case management? All right, now we're in 911, and this is where you go for approval. This is how you get your approval, and it covers all of the categories that can be approved. All right, you go to one rule, and you have one application process. And again, we're going to be developing these forms. You'll probably check, I'm applying for this or that or what have you. And the documentation then is set out. These things here have been required of mediators. They're in the statutes, like that you have to have a sliding fee scale, all of that. So that's not new. This is a little bit different. The current practice is, I think you have to report a misdemeanor or felony. And we had a lot of conversation about the fact that that could hide something like domestic violence, where somebody pleads to something different than what originally brought it in to the court. So this is what we came up with now, is that you have to put down the history, which would include pleas and diversions. All right, doesn't mean it's going to stop you from being approved, but that there will be transparency. Otherwise, these are all what we already have gone through as mediators in terms of these verified statements. That's just going to be signing off your application, because you're going to sign under penalty of perjury that everything's true and correct. So that's all that means. It's not going to, you're not going to have to go down to the the KBI or something like that. The fee. Waiving requirements has already existed, and this just puts it into writing. Okay, the prerequisites for approval. Again, for mediators, it's basically what it is in the existing rule. What I want to point out here is in the definition of core mediation. We say it applies to neighborhood, community, small claims, and other similar matters. The current rule also says education, farmer lender, Those have been taken out, largely because you can't do them without additional training. Education, you got to take special ed training, mediation training from the Department of Education. You have to take special ag mediation training from K-State. So it was and there were people who were actually misled, thinking they could do all of that stuff without anything more. So to be clear, that got pulled out. Victim offender was also pulled out because in practice you have to take, the programs require you to take supplemental mediation to learn how to do either circle process or learn how to do the special process of mediation, because it's not really two equals coming together. So you have a little different approach, and it's now actually called victim offender dialogue and not mediation. So that's why it was pulled out as well.
So is it not considered mediation anymore?
Well, it is not considered core mediation, that's all you need to do it. And I've had questions asked already about, well, why don't we have something there for restorative practices, for example, or victim offender dialogue? And I explained that right now it's not monitored. There isn't special training put on by the state or required. That I think that it's probably one of the next processes, particularly restorative practices and circle processes, but I think we're still evolving in terms of courts ordering those things in a consistent way, and that we need to look at that as something that can be added, like maybe arbitration. In the meeting this morning, we were talking about family law arbitration. There's a push now to have that used in Kansas, which would be different than case management, even because the arbitrator, that can be your final resort, actually. And is used apparently on property disputes by wealthier people. Well, it's basically rent a judge by your judge. So we can always add, but right now it's not in here because it is a different creature than just core mediation. So if and I always tell people who are concerned about that, report on it. When you report what you do, report victim offender dialogues, report circle work. Just because it's not in here now doesn't mean that it won't evolve to the point where it needs to get in here and be regulated in some way. You will see that parent-adolescent mediation has been bumped up from 14 to 16 hours for the additional, the special training. Core remains what it was, domestic remains what it was, general civil and juvenile dependency, that's all in the existing rules in terms of the requirements and the training. Here's the practicum requirement as opposed to the co-mediation requirement. There's a separate rule on what has to be in a practicum, okay? This just says that you have to participate in an approved practicum for the area that you're seeking approval. So if you're seeking approval as a domestic mediator, a core level practicum isn't going to be adequate, okay? And you can get dual approval. Again, this has been a practice that evolved, but there was never anything in writing, and it was hard to always explain. And as we went from one director to another after Art had kind of developed this concept, but then we had to keep educating each director, hey, we used to be able to do this. So now it would be codified, so to speak, that you can qualify as core plus a higher level, so long as you have the core training, you have the additional level of training, and your practicum is in this level of training, your highest level of training, okay? That you can do that. This, I want to point out, the practicum, just as with co-mediation, says it has to be done within a year of completing your training, but you can get that extended, and in most cases, I am unaware of a domestic mediation practicum being able to be completed in 1 year, because you can't predict what cases are coming, you can't predict how long they're going to be.
Can't predict people coming.
Yeah, right. That's right. So that's something that everybody just needs to know, that this is not different, and it is it's easy to work with. So now we're to our new specialties. Domestic conciliator. What do they have to do to get approval? They have to be, as we looked at in the chart. These are just the requirements that were in the chart. So we don't need to go through those. Parent coordinator, also what we saw in the chart, and case manager, what we saw in the chart. This appears to be something that we're going to have to point out, that it got taken out one place but not this place, in terms of this appears to allow CSOs to do case management, but that is not the intent. And that probably will be taken care of after the comment period. So don't be alarmed if you notice that. That they need to be an approved mediator, and the rest here was also in that chart. So this is now the review process. If the director were to, this says the director has to review, has to either approve or deny, and before approval or denial, the director can request additional training or more information, okay? And if there's a denial, then you make a written request for reconsideration. This was already happening. It was just nowhere in the actual rules. Renewal falls here. It says any approved mediator. And right here is what is supposed to grandfather people in. I'm not sure it does. I plan to, we've talked at it with the council, and it will get raised as a comment for the court to see if it does what it's intended. Is that the assumption is you go into these rules as an approved mediator. So that's what this is meaning, an approved mediator, including a mediator approved by Rule 902 prior to its repeal, must, and maybe that just needs to go after mediator, to be clear, applies for annual renewal. But that's the intent right there, to grandfather.
What was Rule 902?
Yeah.
What was that?
That was how you got approved under the old rules. That was the equivalent of 9/11. Okay. So one way or the other, we're going to make sure it's clear. Okay. I've already had that question from people to make sure that if we think it is, that the court really agrees that we're doing it, the right language. So failure to renew, this, I don't know if it was explicitly in the old rule. Failure to submit the renewal application and fee may result in non-renewal of approval status. And if you don't somehow you get to appeal that, but if that's denied, you're starting over with your application for approval. And that's in here a little bit later. So the application for renewal is basically what we've done, proof of compliance with continuing education. And I want to point out now that it's CDRE. It's not CME for mediators or CME for case management, continuing education, or CPCE. It's all CDRE. And so when Dawn approves continuing education, she will be approving it for CDRE. And that when you look back in each of the rules that says, I will get my 6-hour CDRE, it's whatever is approved as CDRE, even if maybe most of it applies. It's a general thing like communication skills for families or what have you, that could apply to parent coordinator, it could apply to case manager, it could apply to domestic conciliator. So I have had a question, do we have to get continue education as case managers and continue education as approved mediators? And the answer is no. As long as it's approved for CDRE, you've met both those requirements, okay? In other words, you don't got to get 12, get 6. So you have to report the number of cases and type of cases, a statement, which is just signing your form that you're going to comply with the rules, and the fee requirement. Again, director can waive requirements. Renewal of approval is reviewed in the same manner as for approval earlier. Here on non-renewal, if you don't meet the renewal requirements, you must apply for approval all over again. Okay? So it's really important to get within the time, get your compliance. It's now a calendar year. You got to go through, get it by the end of December, not into January, which I think sometimes people feel that they could do because you could turn in your application by January 20. And so if you could get something in the first week of January, that it might apply, okay? And that there will be a list kept, and if you want, you can opt out. And apparently there have been people opting out who don't really want to take any cases, but they're still continuing their approved status just in case, but they don't really want anybody calling them. So it is possible to opt out. Any questions on the approval process? All right, mentor mediators. Another initiative that Art had taken up was to try to put some structure to the mentor mediator qualifications and process for becoming a mentor mediator. And in the early or mid 2006, 2007, somewhere in there, there was a group put together. I was on it. And we developed a curriculum for training mentor mediators and a recommended sort of best practices and forms and qualifications. And it was a proposed policy that was never finally approved by the council. But a lot of that is now included in the mentor mediator approval process here, and also in the training that will be that is required. In order to become a mentor mediator, you're going to have the requirements under C of this section, which has to do with how many cases you have mediated. You have to have we'll go through those. But in addition, you have to have letters of recommendation that you actually have the temperament and the personality to be a mentor mediator, because we all know people who are terrific mediators, but not really good at mentoring and teaching and passing on whatever makes them great. Here, emotional fitness in any event. So that's going to be important. That you comply with the rules and you pay the fee, can again waive requirements. So here are the requisites for being a mentor: be an approved mediator, have served as a lead mediator, not just a co-mediator, but you would have to be designated as a lead mediator for 10 mediation cases in the area for which you're seeking to be a mentor. So if you're a mentor, want to be a mentor only at core level, that's all you have to have done 10 cases of. But you can't count core cases to become a domestic mediator. You have to have been the lead in 10 domestic cases. Or civil would be for civil cases. Have completed, this is new, 40 hours of CDRE after becoming a mediator. So we want experience, sort of just both experience in the practice, but also that you're growing with the profession and you're continuing to train yourself. And then either 6 hours of the approved training, which we are working on dusting off that module and getting it ready to go, or have completed a course, a mentor mediator course prior to the effective date of the rule, and served as a mentor on or before the effective date of the rule. And you have to provide the course agenda, hours completed, and proof of attendance. And we have all that for people who took those classes twice. Now, if somebody had mentor training in another state, they'll have to do this. But this stuff is already on record, that the agenda of the course and proof of attendance. I have proof of attendance because we had people sign in at that point. So, and I've given that to Dawn. So then there's a review process again. If you're rejected as a mentor, it's similar to what we went through before. And you have to renew your approval. And in the renewal, you have to show the number. I don't think you're going to have to say the name, but you got to show the number of students, and that should correspond with some of what she at least is getting, or she'll know that those students didn't come through anyway, or if they did. And this is the same waiver.
Tracking the number of students, though, we haven't done that in the past.
You don't keep. You don't have like little files on your student. Well, see, what will happen is in mentoring. If we go, I'll show you. Yeah, this is just the approval. Then we will have. There's another rule on. What you have to do as a mentor. Okay, so then program approval, a lot of this tracks the program requirements in the Dispute Resolution Act, like that you have to have a sliding fee scale, and you have to provide lots of documentation. When it refers to 5507A here, you have to have things like your plan of operation, your objectives, the population served, etc. That's not new, but most programs, I don't know if, that's been a long time ago that a lot of the current programs have turned that in. It's not clear whether this is grandfathered, and that's one of the questions that has to be clarified. If you're already approved, are you going to be approved? Because there's some additional requirements that you have to have your sliding fee scale. You have to verify that your courses will meet the requirements of 914 and that your CDRE will meet the requirements of 914. You have to identify what dispute resolution services you provide, what training courses you provide or will provide, and what CDRE you will provide. And my assumption is, again, you're going to have a form here that will be able to, fill in the blank, or it's going to be fillable online. So it's not really, that should clarify exactly what some of this is. But this is why I'm not sure they will be grandfathered in, because some of this is new. And again, the review is very similar to the other in terms of approving or denying, and then you can appeal and request reconsideration. Renewing of the approval, you have to provide an annual report. Now, my reading of the current Dispute Resolution Act is that programs were supposed to be providing a report. I don't think that's been actually required, but that is in the statute. So this is pulling some of that in, that it's complying with 507C. That's where you were actually supposed to provide. Each approved program shall submit an annual report to the director. And the report shall include the number and types of cases handled in the year and showing of continued compliance with the Dispute Resolution Act. So that's what that is.
Now, I always did one for art with my program.
I know he did, he used to do that, but that fell off at some point. I don't know if it was just when he left
Because my
or he got
program's not there
over,
anymore. They
yeah.
dropped the
But
program.
we had a program where we used to do it also at KIPCOR, but it wasn't done in the last few years that Art was there either, so. Anyway, that will change. It has to summarize your dispute resolution services or approved training, identify the number, types, dates, agenda, and approved CDRE hours. If you do, and then you do these verified statements again each year, and there will be a fee, which I don't know that there was a fee in the past, but there will be an administrative fee. Won't be significant,
I
but
think there may have been a small one.
initially, but not annually. So there'll be an annual renewal fee like there is for other specialists. Again, the waiver, the non-renewal, and there will be a list of approved programs on the website indicating the types of services, fees, and region of services. All right. The primary training courses, this is what we also spend a lot of time just educating Dawn and some of the other staff help that we had about the difference between continuing education courses and the courses you had to take to get approved, because it felt like it was all just education to them. And why was there approved trainers required for part of it, but you didn't have to have approved trainers for CME, and they couldn't figure that. So we spent a long time on that. So the approval education is now called primary training, and the continuing education is called CDRE, and they have two different rules, okay? So these training requirements are virtually identical to what was for mediation, what was in the prior rules, and then we have added training requirements for mentor mediator, which is coming from that work we had done a long time ago, and those courses back in the early 2000s. And then we have training components for domestic conciliator, parent coordinator. Parent coordinator is taken a lot from AFCC, and case management, which is what is sort of has developed as being required in case management. So we tried to make these reflect actual needs and practice. And I'm not going to go into any more detail on that unless you guys have questions on that.
And you said that you weren't sure if current mediator mentors were going to be grandfathered in.
Right. Well, no, we know that, yes, if you recall what I pointed out on mentors, let's just go back and point that out.
Some extra things on there now.
No, what's on for mentors? Here's what you have to do to be a mentor. You have to be an approved mediator in the category you want to mentor. You have to have been the lead mentor for 10 mediations in that area. You have to have completed 40 hours, and if you're experienced at all, 6 times
I
whatever.
have 20 to 40.
Yeah, I mean, most people, that's right.
I'm a training junkie.
Most people have more than what you need, okay? As long as you have the proof. And then here, you either take the course that's going to be in that training, or you took the course, a course. It doesn't even say it has to be our course, but you took a course prior to the effective date, and you have mentored students, okay?
I have not taken a course, but I was
Yeah.
previously.
Yeah, then you would have to do this piece, unless you can, you can explain
If
that.
she does another course, I want to take it.
Yeah.
I have signed up at Johnson County Community College when they've offered the mentor training, and they cancel it.
Yeah, because they didn't have enough people.
They have enough people.
Right,
So I've
right. We will have enough, I think, now, because there's plenty. Yeah, there's been plenty of people in your situation, because she couldn't require it. All she could require was the experience. Okay, so that's why we had that odd situation. And if these rules don't go, we're probably still going to offer it. Okay, because we feel like we just get a lot of requests for forms and ideas on how do you put together a practicum and all of that. So anyway, does that answer your question?
Yeah, just gotta find time to do it.
Yeah, yeah. Or you know, you can try to argue for and ask Dawn to waive it and, you know, establish that somehow you've had the pedagogy, but I think that's what she's interested in, is the pedagogy of adult learning is a little bit different than for other kinds of teaching. Okay, so we're done with that, and then we have the mediation practicum. This is what mentors have to offer. They have to get their practicum approved. And this also is coming from that work we had done earlier. So this one is going to require a written mentoring agreement, which has often not been done. And the agreement has to include these components: an explanation of the mentor's expectations and procedure. For example, in my agreement, I will say it's for a year. During that year, you can call me, you know, and I often extend that in terms of students calling me after they're doing their own cases, that the way they're going to have a journaling requirement, a reading requirement, and they're going to have a graduated involvement. This is what they're going to do in their first case. This is what they're going to do a little more in the second. And that's all coming out of that training that we have, and we have that all worked that out.
That's one thing I haven't been able to get K-State to do.
Yeah, we don't have a written.
We don't have anything in writing, and then I have never done more than 2 with anyone.
Yeah, and I know there's some different models, and we've talked about that, and there's a waiver here so that even though in this rule, as we'll see, it requires that you do at least 3 with the same mentor, because if you're clicking, that's great.
Right.
But I know there are some mentoring programs where they deliberately want you to do more than one.
Well, and that's okay, but I think the one that does all the letter writing should do at least 3.
Well, I think in the program we're aware of, the one who does the final evaluation does at least 2. Okay, and so in any event, when Dawn heard about that, she said, come to me. That's why we have waiver requirements. If it still works pedagogically to get us where we want to go, she can approve on a case-by-case basis. Okay, but this is sort of like the template that we start with. So you have to explain your expectations and procedures, explain your fees, how you're going to, you know, for example, in our case, we do $25 an hour. That's for all contact time, all time that I'm reviewing their agreements, all time that I am going over their journal or what have you. It's not just time in the mediation, it's time prepping and debriefing after a mediation. And they pay the initial 10 hours at the beginning of each case, and if the case runs over that, then they know they're going to get billed for the extra. So you have to have that all in your written agreement. A statement confirming that the mentor retains ultimate responsibility, and again, this is all in our sample that we handed out in that training. And I'm sure there will be templates like this and any other information deemed necessary. The practicum has to be supervised or conducted by an approved mentor. We have this in here because there are some programs where you might want to have somebody either work with another mediator who's not a mentor, but to get some experience. But then your mentor has to sit there and basically supervise to be able to evaluate and review. This was, I think, originally put into our proposal long ago when we thought we were going to do a lot of role plays. And to do role plays, you might use somebody who's not a mentor mediator to help provide evaluation and feedback, but it all had to be under the supervision of an approved mentor. I think in reality, the mentor mediator is going to be there doing it, but it gives some flexibility. You have to have written approval of the practicum before you can offer it. And the practicum has to include at least 3 cases consisting of co-mediations, mediation simulations, and here there was all kind of confusion about what are these role plays and what were the role plays in the initial training. And so we're calling these simulations, and in your initial training, those are role plays, okay? So that's why we have a different word here. Or a combination of co-mediations and mediation simulations. Sometimes I have students who are so scared that they want to do their first one as a role play, and that kind of gets their feet wet. And when they role play, they are not co-mediating. They're doing the whole thing by themselves. But then they go from that to two or three co-mediations. Be supervised or conducted by the same mentor mediator unless the director waives this requirement. That's where that is. And the director or designee may attend or monitor or observe. And this line, I haven't pointed it out before, but it exists in the basic education training, or the basic training, and in the CDRE, that, you know, she or her designee can pop in at any time. Now, these are the approved mentor's responsibilities, which are really significant in terms of being different from what was in the prior rules. You have to provide assessment and feedback, you have to provide for participation, and you have to provide for evaluation. And then we define each of those. So assessment and feedback, at a minimum, should cover the following: the process and practice of mediation, including techniques and skills. If this is supposed to say process and time management, it's a typo, which I will point out. In other words, we want to have students have practice in, when do I take a caucus? Or when is somebody upset? Do I need to do something now? You know, has this session gone long enough? Is it time to break? So we really want, that's what we want, practice of managing the process. Agreement writing, maintaining neutrality and ethics. So at a minimum, the mentor has got to provide evaluation on those. Participation, the mentor has to engage the prospective mediator in the actual practice of mediation. Okay, now there may be other ways to do it besides the graduated model that we have, but this won't work. A prospective mediator who solely observes a case without further participation will not meet this requirement. We wanted to make that really explicit because that has happened a lot. Okay? And then evaluation at the conclusion. You have to complete an evaluation on a form and in the manner the director prescribes, so that there will be an approved form for doing certainly the final evaluation at the conclusion. And you're going to be expected to give feedback all the way along, but it may not have to be on a formal form, okay? In the evaluation, you have to assess whether the prospective mediator has demonstrated the required basic skills and knowledge to be an approved mediator. So we're acknowledging that mentors are basically the gatekeeper. If you can't get the mentor to do this, you're not going to be approved, okay? If you have a personality clash, then that's one of the grounds on which you would ask for a waiver from having to do it all with just the same person. Okay, so you don't get stuck where it's going to be impossible for you to get through the gate. All right. So the skills and knowledge to be approved, and you provide a copy to the mediator. Any questions on the practicum? A lot more than just that little bit on co-mediation in the old rules. That's significantly different. Okay, CDRE compliance period is going to be with the calendar year. Some things that are different here is And here's where it's a general CDRE requirement, not per specialty, okay? An approved individual has to earn 6 CDRE hours, okay? Of the 6 hours, 1 has to be in domestic violence or ethics. Okay, so really what that means is the people who are putting on the training are going to have to pay attention to saying this little piece here qualifies, and they're going to have to get that approved by Dawn as qualifying for one of those. And so you're not going to necessarily have to hunt, but for example, when KIPCOR puts on its 6-hour CME shorts, it will want to be sure it has that extra 1 hour there for people so that everybody's getting it all taken care of at once. Which doesn't mean you can't hunt and take a 6-hour, domestic violence training, and that would take care of everything. All right, then here is just how the 50 minutes works, and basically saying you can get credit, half credit, for 25 to 50 minutes, but you get no credit under 25 minutes, okay? And this has been the rule, but it was never written anywhere. There's no carryover credit. So if you get 40 hours, you only get to count 6, okay?
I guess people would try that.
Yeah. So approval, this is just, if you're going to offer it, you have to get the approval, written approval from the director, which has just been the practice. And if it's not approved, you have to go through and supply the information that the director wants. Here's something new. You can get credit for teaching. And you can get up to 5. So you don't get, you still have to get your 1 hour separate.
That makes sense though.
Now there are some limitations that you have to submit a written request for this credit that outlines the program content, teaching methodology, and time spent in prep and instruction. And the director will calculate the time. And if you do a repeat, like I teach domestic mediation regularly, I could get that, but only for the number of hours of time actually spent updating the presentation and teaching, which is still going to get you 6 hours on a domestic training course. Here's another specification. Instruction has to be directed toward an audience composed primarily of dispute resolution professionals. CDRE credit will not be awarded for teaching undergraduate, graduate, or law school courses. Now, I think that what this means is that at Johnson County, while I don't know if they give credit for some of those courses, but even if there were undergrads in there, if the audience is primarily dispute resolution professionals, it could count towards CDRE credit for the teacher. Then you can get credit now for authorship, all right? And again, it's up to a total of 5. And you get it if the work is a published article, chapter, monograph, or book personally authored in whole or in part by the person requesting the credit that contributes substantially to the education of dispute resolution professionals, and the publication occurred during the compliance period. Okay, so we've got a little bit of other ways people can get credit. And other activities can be approved if the director thinks that it promotes and improves the practice of dispute resolution. So it's possible, some of you might say, I went and talked to the Chamber of Commerce, and for 50 minutes, and here's my presentation. It's possible that she might say that's worth it.
What about, I don't know if you said mentor mediators mentoring. Does that count?
I don't think anybody has ever thought of that.
It seems like if all of these counted, that would
it's a kind of a teaching,
too.
yeah. That's interesting. I hadn't thought about that. That's worth exploring. But I think all you have to do is go under this and make a request here. And exemptions from CDRE for good cause such as hardship or disability, which has been practiced now. and that she will keep a listing of approved CDRE courses, which she does now. Any questions on CDRE? All right, 917 is approved program providing training courses in CDRE. And this, in effect, what we're doing here is Dawn really wanted to find a way that she didn't have to require people to go through all the rigmarole every time they offered domestic mediation training. If the course was basically the same, the instructors are basically the same, you know, and it's been through the approval process once, that's really the significant difference here, is offering it again. If there's no substantive changes and you notify the director in advance of the subsequent offering, you can go ahead and offer it without having to submit your agenda and all the rigmarole. You have to keep track of the attendance, and you have to keep evaluation summaries for each course on file for a minimum of 3 years. And then, if you'll recall, you're going to have to report that in your annual report. So that's another way she knows who's doing what on the training in CDRE. So she has the same language in CDRE in terms of repeats, right here. Okay, so that's the reason that this exists. It was hard to figure out how to write it, but she feels like it's going to cut down on some of her duplicative administrative work, and that work is not necessarily necessary as long as the course is there aren't substantive changes. Otherwise, this is pretty much what's been going on already. Here is the other big difference on trainer requirements. Now, this applies to the training courses. This is where we used to have approved trainers. And all you had to do to be an approved trainer was coach at 3 trainings. And you never even had to teach at 3 trainings. And you had to have done a certain amount of practice. But it wasn't much of an approval process. So an approved training course now must be presented by a person or persons qualified by practical or academic experience to present the subject. So this takes care of places like Washburn Law that has a mediation course that's taught by an academic who has never mediated a single case. But
1 year.
okay, all right. But
Yeah.
but and KU has one that is not taught by anybody but an academic. So it allows for that that the person is if they're qualified by the school to present the subject. However, here, at least one of the persons presenting must have 3 years of practical experience. So even if it's primarily run by an academic, somewhere in that course they've got to bring in as a and ideally most of these courses have a practice component. That's where we get the practical experience. So
What we did for 1 semester is we put them through a lot of practice and they didn't like it at all.
yeah, right, it's different. But hopefully this gets the expertise that we need, and obviously we'll see, the feeling is the market will weed out where you don't really have a competent instructor, and that this will get us as close as we can get without turning into an accreditation agency, which is what she really wants to avoid. CDRE does not have this because we have not ever required it of CME presentations. Could be by a psychologist who was not a mediator but could teach us some interesting things about high conflict people. So it doesn't exist in the CDRE section here. Otherwise, it is pretty much as we've done before. Any questions on education?
You guys were putting together that class sometime everyone had.
Ethics, this has most of the, has all the ethics rules that we had before. I want to point out again just things that are different. In the impartiality, because this applies to everybody, including case managers and parent coordinators and domestic conciliators who might make reports and whose work is not confidential, and the reports might seem to favor one party's position over the other, you might say, well, how can they be impartial? So, and they can be impartial in how they do their work in a fair and balanced way. So we have this sentence: an approved individual employing a dispute resolution process that requires a recommendation does not by itself establish that the approved individual lacks impartiality. That alone won't be enough, okay? In the old rules, we had something about not taking a gift or compensation improperly. Now we've added this exception. You can accept or give de minimis gifts or incidental items or services that are provided to facilitate a dispute resolution process. Maybe that might mean having candy on the table. Or respect cultural norms, because we know that there have been some instances in small claims where the family wanted to come and give some food or something as a thank you for having helped work out a dispute. Whatever, we wanted that to be an option. Let's see. On conflict of interest, the conflict of interest language is has to work for attorneys as well, and this language here, or for people who might be therapists as well as mediators, that in general you have to avoid the appearance of a conflict both during and after the dispute resolution process. And this one here that says you can proceed with the dispute resolution process after, even if there's a potential conflict. Out in rural areas, there's a concern that somebody can be a mediator, a case manager, and an attorney. And they might have been an attorney for somebody that they're then appointed to be a case manager for. Or they were a case manager 10 years ago and then somebody comes to be the attorney. And there's so few professionals that it can be a problem. So there are efforts here to allow for that to be disclosed and for parties to agree to go ahead. But there is also this which says if the conflict of interest casts serious doubt on the integrity of the process or impairs the approved individual's impartiality, you just need to not take the case, even if you could get the parties to agree in writing. Okay, so that just tries to give as much flexibility as we can while still taking care of the problem. Let's see, confidentiality is pretty much standard. Quality of the process, one thing that's been added is you might have to distinguish dispute resolution from therapy or counseling. So that's a new ethical requirement, is to make, if you think people are coming to mediation thinking it's really kind of like counseling, you have got to get that cleared up. And I had a case where it was an elder, and I think she really wanted counseling, and I kept asking her, are you sure you don't? No, I want this. And I said, and she kept wanting me to do things in relation to her daughter, grown daughter, that were really a therapeutic kind of an intervention. And so we had to go through that over and over and over again. So that's now an ethical obligation. As an ethical obligation, this is something we used to teach people, but I don't think it was in ethics. You're going to have to now explain as a matter of ethics what a caucus is, or when you will take separate sessions. And as a matter of ethics, you have to explain their right to seek independent legal counsel. We're down in F here, for advice throughout the process and before any agreement is signed. Okay, and I know sometimes we have mediators that maybe do everything in our neck of the woods. They try to do everything in one session and get people to sign off. That's not going to work here. I mean, they at a minimum are going to have to say, you know, if you want to run down to your lawyer's office, or you at least need to call them on the phone or something. So that's a new addition.
You don't have to stop the process though, right? You just have to say this is your option if you want it.
Here you have, yes, you have to say you have a right to seek advice at any time, and then before I have them sign it, I have to say, now, you have a right to take this to your attorney and have them review it before we sign. You know, if you don't want to do it, okay, you're informed, but I have to make clear.
I like that because I don't like it when mediators pressure people.
Yeah, I think ultimately it's a great idea, but I know there's different ways of practicing. But I think this is now going to require a little adjustment on that.
But it's not sufficient to say all that at the beginning
Right.
of the whole process?
You have to do it twice.
Oh, okay.
That's how I read this, anyway. You do it, this is what you have. You can get legal advice at any time through the process, and before I can say this at there, but my assumption is somebody could go after you, I think. I'm interpreting it in the way to be most cautious. I'm not saying that that's what it would be read to be, but I'm saying because we now have a complaint procedure, and the complaint procedure says if you see a violation of any of the ethics, you can file a complaint. That somebody might say, they didn't tell me that before I signed, and I don't like that agreement now. You know, I would just do it to be careful. Even if it causes some delay. I don't want to be that afraid of my agreements that if a delay is going to blow it up, it's going to blow up anyway, and I don't want it signed. Okay, then we've got advertising is pretty similar. Fees and charges, there's some new stuff here. C, under 7, you have to return any unearned fees. So if you took for example, we often say we need to get paid up front for a minimum of the first 8 hours of mediation. If my mediation only goes 6.5, I have to return an hour and a half. Now, I include not only my time with the people, but also writing up the agreement. But if still that's less than what they paid for, I return. That's pretty rare, but this is now an ethical obligation. Unless the court has ordered in some way that you're going to pay. I know for case management, sometimes the court will say, you pay the equivalent of 10 hours flat fee or something, you know. But otherwise, if it's unearned, the ethical obligations, you got to pay it back. And that you have to keep records. I'm not sure all mediators keep records that support any charge for services and expenses. They may just say, okay, my fee is $250. I'm not sure what records have to exist for that, but it seems to me, if I were doing it, I would say, okay, I'm going to have evidence that I met with these people on this date, and I met with them for 5 hours, and they paid me $250. I don't charge per hour, but I did this work for that amount. You know.
What about the people who no-show though?
Well, I always keep records of who no-shows.
Yeah, but like on here, do you give them back the money?
Well, they haven't gotten any services.
Yeah.
So, you know, they may not have paid either. That's usually the no-shows in my experience.
I've had both.
Yeah.
But I've had people say, I'll be there 15 minutes late and then not show up for an hour later when we've already canceled.
Yeah, well, I'm assuming nobody is charged. You've only maybe done 15 minutes, and that can go as 15. I was there for 15 minutes, but you wouldn't. And everybody would pay for that, for you having to sit in the room and wait. Yeah, that would be appropriate.
Or their hour.
So this isn't precluding cancellation fees or no-show fees?
No, it is not. As long as you've put that in your written agreement. Okay, absolutely. That's part of your process. That would be considered an earned fee. That's the other reason why you want to get it all out there, because you don't put something else in that time slot. You sit there, you wait, you maybe call. I mean, it's related. Okay. Then here we have another thing related to the dual, multiple, or sequential roles that I talked about earlier. An approved individual must not serve in dual. In other words, you can't be a mediator and then a case manager. Multiple.
Same family.
Yeah, and the same dispute anyway. Or sequential roles. That's, be the mediator and then the attorney, whatever. That may create a conflict of interest unless all participants in the dispute give informed written consent. And I would say, back on that other ethical obligation, some cases are just so, they present such a potential for a perception of conflict that you shouldn't get yourself involved anyway, because you might get started and then it goes south for somebody who said they agreed to it, and all of a sudden, hey, you really did have a conflict. You're not being fair. So you got to use, common sense. Sometimes you just don't. This is a whole new section, self-reporting professional misconduct. So everybody wants to, take a good look at that. These are the things that you have to come forward and share with the director. And again, how you do that, if you call her up and has a sit down, or if she has a form, or if it's going to be on the yearly renewal form. I don't know where that's going to be or how it's going to happen, but this is going to be an ethical obligation. And to report criminal conduct that affects your, relates adversely to your honesty and trustworthiness, conduct that involves dishonesty, fraud, deceit, and misrepresentations, that's prejudicial to the administration of justice or dispute resolution in Kansas, or any other conduct that adversely reflects on your character, fitness, and general qualifications to practice. You've got a responsibility, with those of us that work in programs where there's staff, you have to supervise your staff to ensure that they follow the ethics requirements. Self-determination is just language that was in the prior rule. It's just been put specifically in detail in here. Approved programs also have this oversight of both their staff and any practitioners that work for them to make sure that they are following the ethical requirements. So these are the separate requirements for approved programs under ethics. And then they have to assure their programs comply. And then approved mentors have separate ethical obligations. They have to follow all the ethics requirements, and they must provide competent instruction to prospective mediators, and competent instruction requires coaching prospective mediators and sharing knowledge and expertise. So it's not just having somebody watching. So it's just another way to get at that problem that we have had. Any questions about ethics?
Question on confidentiality.
Yeah.
Some civil mediators tell people in the caucus, unless you tell me otherwise, I will assume everything in here is confidential.
Yeah.
Some say, unless you tell me otherwise,
Yeah.
I will assume everything here is not confidential and I can share it in the other room.
Right.
Do the rules have any effect on either of those
It just means that here's what it says right here. Look under 4 is confidentiality.
Uh-huh.
An approved individual must maintain the reasonable expectations of the parties with regard to confidentiality. And in the earlier rules, you have to have in writing in your agreement a statement about whether it's a confidential process or not. The order of the court has to say, is it confidential or not? And so as a mediator, you may want to put in writing what your caucus rule is, and at a minimum, you need, because you also have to explain caucus, remember? Now we have to explain caucus as an ethical obligation. That when you explain caucus, you have to say which it is. The best protection is if that's in writing.
So for example, you'd be fine if you said something like,
None of it's confidential unless you tell me.
Right,
That's your
right.
that's their expectations then.
Right, okay.
Okay.
Great, thank you.
All right. Now quickly, what's left are the complaint processes, and essentially what you need to know is if the complaint is about a case that's ongoing, they have to make the complaint to the judge. That's what Dawn is doing now. She sends people to the judge if the case is alive. All right? If it's after the case is done, you can go to Dawn. All right? Or if it's over multiple cases that are done. All right? The next thing is that if you file a complaint... Let's open this up. If you file a complaint, this is what has to be in it, in addition to just the standard stuff about name and address. You have to identify the specific provisions of the ethics rule, 918, that have been violated. Now, 918 is going to refer back to some of the other requirements in the other rules, but you have to hook it to an ethics rule, okay? You can't just say, you know, they're not qualified. I mean, you got to figure out the rule there. And a detailed description of your effort to informally address the incident. So they have to have come to you and tried something. Then, in effect, the director conducts an initial review. After that, the director can dismiss the complaint, or if it's considered frivolous, or they refer it to the chairperson of the advisory council. So there's a minimal review there. Then and the director can request an investigation further on their own initiative, but generally we'll go to this rule, 920 investigations, where once it goes to the chairperson appoints a current or former council member to investigate. Okay? So Dawn is not going to be investigating these other than that initial review for something that's frivolous. If it has merit, it goes to the chair. The chair appoints someone from the council or a formal council member to investigate. This is similar to what's done in other professions, where people in the profession basically volunteer to investigate complaints. So we followed most of that format here. We didn't dream this up. And so then that investigator would write a written report to the chairperson and recommend either dismissal, additional training, or suspension for a period of time or indefinitely. Okay? And then we go to 921. So if the chairperson then has to take that investigator's recommendation and make the final decision and issue a final written determination. That's forwarded to the complainant and whoever was being complained against, individual or program. Now, and the chairperson's determination is final if there's no appeal filed. Now, this is important. The only people who can appeal are the people who were complained about, not the complainant. Okay? So the complainant has to live with it if it's dismissed, or if they don't like what the punishment was, that's what they have to live with. But the person who's affected by a consequence is probably the person who would then has the right to appeal. It goes then to the Supreme Court. Chief Justice appoints a 3-person review panel, and that panel has to include at least 2 current or former council members, and one of those members has to be someone who has practiced in the area or run a program similar to what's under investigation. So there, like if it's a complaint against a case manager, it has to be at least one council person who has been a case manager. So we have somebody who knows the field. And then they do their review, they submit a written determination direct to the director. Director forwards that to the chairperson of the council, and the individual who whoever did the appeal, and that determination of that panel is final. If you are an attorney, it gets reported. If there's a negative, it gets reported to their disciplinary administrator, because that's required, apparently, under that rule. And if it's someone who is governed by another licensing body, like the behavioral sciences, the director may. Probably would depend on what it is. Okay? And then this is immunity for all the investigation, and then these are just minor changes in the name. So that is the review packet. Are there any questions that we haven't covered?
I think Dawn has a big job ahead of her.
Yeah, the council and Dawn has a big
The
job.
council's going to be writing a lot of forms.
Right. Right.
I had a question.
Okay.
It's a general question. Earlier on, you kept saying certificate of approval. Are we changing the way we're saying state approved mediator?
No,
to-
it's approved, but you get a certificate. Like right now, we get a certificate. But we are not we're not certificated. We're just approved.
Okay.
Okay. All right, thank you for coming, for braving the weather. Thank you for the videotaping, and we're done.
Thank you.
Thank you.
Yeah.
Glad you were already up here because we couldn't come back.